Denver County Court, Virtual Advisements. Civil. Welcome. You are here today because you are a party to a civil lawsuit and are appearing as either a plaintiff, who is the party filing the lawsuit, or as a defendant, who is the party being sued and responding to the lawsuit. The purpose of this advisement is to provide you with important general information regarding your civil case in the Denver County Court. Civil lawsuits revolve around two items: money, such as lawsuits for credit card or medical debt, or property, such as an eviction case. Civil lawsuits are matters between two private parties, and as such, if the parties have not already done so, it is highly encouraged that they meet and speak with each other and attempt to resolve their issues satisfactorily amongst themselves. Oftentimes, this results in a much better outcome for the parties when they can reach a compromise, instead of having a court hearing where one party will prevail and win the case and the other party will not. If an agreement is reached between the parties, then both will sign a written stipulation which will be filed with the court indicating the outcome of the case. If you are here on a money case and need more time, you can request a 2-week continuance. Continuances are not granted on eviction cases. Both the plaintiff and the defendant are entitled to be represented by an attorney if they wish. As these are not criminal cases, you are solely responsible for the cost of hiring your attorney. Blank copies of any of the forms mentioned in this advisement, such as an answer, counterclaim, motion, or stipulation, are available in the Civil Division Clerk's office and on the court's website at no charge. If you are the defendant on the case and you have not been able to come to an agreement with the plaintiff, you are required to file an answer with the court as to why you disagree with the plaintiff and if there are any claims you have against the plaintiff. By not reaching an agreement with the other party and filing an answer, you are requesting the court to conduct a trial and make a final ruling on your case. For money cases and property cases not involving evictions, your case will be set for a pretrial conference prior to being set for a trial date. For eviction cases, you will be set for a trial within 7 to 10 days. Answers must be filed before the end of business today. End of business occurs at 4 p.m., Monday through Friday. There are filing fees required for answer or counterclaims that must be paid at the time of filing the answer. In certain circumstances, required filing fees can be waived if the party files a motion with the court to waive the fees and that motion is granted. Motions to waive the filing fees must also be filed by end of business today. Effective November 1st, 2024, by law, filing fees will no longer be required for defendants who are a party to an eviction case. If you are the defendant and you are unable to resolve your case via an agreement with the plaintiff today, and you have not requested and been granted a continuance for additional time to try and reach an agreement, and you have not filed an answer and paid any required filing fees by the end of business today, the plaintiff can file a motion for a default judgment. A default judgment means that the defendant loses the case by default and the plaintiff wins the case. If a default judgment is for an eviction, the court will then issue orders to have the sheriff remove the defendant from the property. If the default judgment is for a money case, the plaintiff may then move forward with actions to garnish wages or other lawful manners to collect on the judgment. A default judgment can also enter against either the plaintiff or the defendant if either party fails to appear at any future court date. Please be aware that pursuant to the Civil Relief Act, the court will not enter default judgments against any person who is currently serving in the U.S. Armed Forces. When filing documents with the court, attorneys are required to use the Civil e-filing program pursuant to the Colorado Rules of County Court Civil Procedure, Rule 305.5. For plaintiffs and defendants who do not have an attorney representing them, documents can be filed with the court in multiple ways. The first way to file is by mailing documents to the court. The court cannot consider a document filed until it has possession of it. Thus, you should mail any filings well before the date they are due. Mailed filings that are not received by their due date because of insufficient postage, mailed the same day as being due or lost, cannot be considered to be filed with the court, even if the delay was of no fault of the party filing the documents. The second way to file documents is by emailing them to the court. Email is preferred over U.S. mail because the documents are received by the court immediately. However, as with U.S. mail, the court is not responsible for email filings that are delayed for reasons such as internet failures or use of incorrect email addresses. Emails where there was a failure to attach any required documents also cannot be considered as filed with the court. Please note, emailed answers only apply to FED eviction cases. Money cases require in-person filing in the clerk's office. The third way to file documents with the court is via hand delivery at the Civil Division's clerk's office during normal business hours. Hand-delivered filings are the preferred way to file documents and pay filing fees. The clerk's office is open Monday through Friday from 8 a.m. until 4 p.m. and is closed on legal holidays. The email address for filing documents, as well as the physical address for mailing documents or hand-delivering documents, will appear on screen at the end of this video. They are also available in the Civil Division's clerk's office and on the court's website at wo.denvercountycourt.org. Regardless of how you choose to file documents with the court, if filing fees are due, they must be paid at the time of filing. Filing fees cannot be accepted on emailed filings. Filing fees for filings made by U.S. mail may be paid by including a check or money order for the cost of the fees. Filing fees for hand-delivered filings can be paid by cash, check, money order, or credit card. Additionally, all filings with the court must include your case number and have all required spaces filled in for name, address, and all other required information, as well as signatures if required on the form. Please also remember that it is your responsibility to keep the court informed of any changes to your contact information for address, email address, and telephone number. Finally, there are many resources available for persons who are involved in an eviction. A list of these resources can be provided to you by court staff in the Self-Help Center of the Denver County Court, on our website, and in person at the Denver Eviction Clinic, held daily in the City and County building. Should you have any questions regarding the civil process in your case, please feel free to ask the Civil Division Clerk's office or Self-Help Center staff. Please be aware that while staff can help you with answers to many questions, they cannot provide you with legal advice regarding your case, including advice on how to proceed with your case. Thank you for your attention during this advisement.